All right, page 59, negligence. Negligence, 100% for sure, will be on the midterm. I ask the same question every single term, exactly, literally a cut and paste. What are the 4 elements of negligence? Duty, breach of duty, injury, causation. I ask that same question every time. In fact, I'm going to show you right now one of my old midterms, so you can see what it looks like. Here it is right here. This is the actual question. I'm literally going to cut and paste this onto you guys' midterm. Okay, you'll see this exact question. So if you get this wrong, it's on you, because I'm showing it to you right now. Name the elements of negligence. Duty, breach of duty, injury, causation. DBIC. And I also commonly ask for 1 or more defenses, which we'll get to in a minute. Now, why am I showing you the test? Because I ask this every term. Why do I ask it every term? Because negligence is one of the most common reasons, if not the most common reason that you might get sued in the real world. Now, what I'm talking about primarily would be an automobile accident. Typically speaking, an automobile accident is one of the most common events that leads to a lawsuit. Automobile accidents almost always are based upon what we call a negligence theory of law. Negligence is also in business, where you most likely might get sued, either because somebody slipped and fell at your store, or you didn't clean the snow off your front walkway and somebody slipped, or if you're a professional like a doctor or a lawyer or a dentist, you commit malpractice. That's a form of professional negligence, or any number of things that we'll talk about tonight. Again, in business, this is most likely the type of case that would lead to a lawsuit, a negligence lawsuit. So, what is negligence? Just in basic everyday language. Negligence is an unintentional tort. It basically means that you have caused some sort of harm to another person, either personal injury, like their body, you physically harm their body, or you damage their property. Maybe you back into the car in the parking lot and damage their car. They weren't in the car at the time, they weren't hurt, but you damage their property. Or you damage their reputation, their business. They have lost profits now. In other words, you cause some injury, either physical or monetary injury to someone else, and as a result of that, you are responsible for payment for those damages, even if you did not mean to do it. In fact, most of the time, you don't mean to hurt somebody or damage their property. It's like, oops, didn't mean to do that. I didn't see you in the crosswalk, or I was not paying attention and I ran into your car, or I didn't see that you were stopped waiting for a pedestrian and I rear-ended you. Didn't do that on purpose, it was unintentional. But I am responsible for payment of your injury and your damages, or both, because I was negligent. That's why I make such a big deal about negligence. It is the most common area where you might get sued. This is also why you want to carry insurance. For your automobile, in your business, you have a general lines liability policy. If you're a professional, you're going to carry professional malpractice or errors and omissions insurance to protect you in case you do something wrong. Or if one of your employees does something wrong, you're liable for their actions under a negligence theory. All right, so DBIC. 100%, what are the 4 elements of negligence? Duty, a breach of that duty that causes an injury. That's why I have plus signs. So, in order for there to be negligence, you must have all 4 of these elements. They must all interlink with each other. And I'll explain that as we work our way through. When you're analyzing whether or not somebody was negligent, I want you to work your way through all 4 of these elements. If any one of these elements is not present or does not link up, then you don't have negligence. And I'll give you an example of that here in a little bit so you understand what I'm talking about. Duty, a violation or a breach or a failure to follow that duty which causes an injury. Now right here, where I say injury, PIPD. Personal injury, physical, harm to somebody's body. PD, property damage. I don't just mean physical injury. Negligence can lead to monetary damages for property damage, even if somebody's not hurt. So it doesn't just apply to bodily, physical harm. It's any kind of monetary, physical, whatever harm that you suffer. You can sue to be compensated for that harm that was caused. All right, so let's start with the first element of negligence, duty. Page 60, next page over. Also a high probability of being a fill-in-the-blank question. Okay, so what do we mean by when we say the term duty? We mean responsibility, obligation, how you behave, what standard do you have to follow. That's what we mean by this broad term of duty. And basically the idea of negligence is that everybody has an obligation, a responsibility to everybody else at all times. You sit here in the classroom right now. You have a duty to everybody else. You're driving down the road. You're a construction contractor. You're a doctor. You're an airplane pilot. You're a truck driver. You have various levels of duty depending on what you're doing. It also will depend upon the circumstances that exist at the time. Your duty may be different depending on the weather, for example. If it's all snowy and icy out, even if it's a 65-mile-an-hour speed limit, it may not be reasonable to drive that fast in the snow and ice, especially if there's a bunch of cars everywhere. So duty may change depending on what's going on, depending on your level of education, your skill level, your experience level, all these different things. So basically the idea of negligence is that you have an obligation, and if you don't follow through on that obligation, you are responsible to pay for whatever harm flows out of your breach of duty. So these are some of the terms we use to describe different levels of duty. There are more than this, but these are the ones that are pretty common. So first, the most basic duty is what we call the reasonable person test. And this is basically the idea that everybody has an obligation at all times to act reasonably, to act in a way that the mythical or theoretical, reasonable, rational person would act. Kind of like in economics, you have the rational person theorem. In law, we have this idea that what you do will be measured against this theoretical, reasonable test. And if what you're doing is not reasonable, or the average reasonable person would not have done that, then you're negligent. You violated your duty. That will also, again, depend on the circumstances. Is it rainy? Is it foggy? Is it dark? Is it snowy? Is it windy when you're out driving? A reasonable person would slow down under those circumstances, put their headlights on if it's foggy out, that kind of thing. That's a reasonableness test. So that's the most basic one. Now, that is not well defined, right? I mean, how do you know if something's reasonable or not? And in some ways, it's like unwritten law, because you don't really have a specific rule that tells you what you're supposed to do. That's up to a judge and a jury, basically, to make that decision. Were you acting reasonably or not? And if not, then you're negligent. All right, so let's move on to number 2, because this is actually more common. So the next area where we say there's a duty is a duty that is created by law, right here. A duty created by law. This is actually much more common in the real world. Most laws that we have, like traffic law, for example, building codes, electrical codes, health department rules for restaurants, sanitary codes for medical professionals, tax law, safety regulations for truck drivers, maritime rules for captains, airline regulations. These are all laws, basically, that create a duty. So the speed limit, classic example. That creates a duty. You need to follow the speed limit or less, depending on the circumstances. Not following too close. Obeying traffic control devices like red lights and stop signs. Those rules, safety regulations for driving, create a duty. And if you violate those rules, you have therefore also violated a duty if it leads to an injury, meaning you're basically automatically negligent. So the term we use to describe this is negligence per se. The term per se is Latin-based, which means in and of its own being, in and of itself. Its very existence, different ways of saying it. So negligence in and of itself, per se, of its own self. I like to just say automatically negligent. You didn't follow the law. Had you been following the law, the accident would not have occurred, therefore you're automatically negligent. In the real world, like most automobile collisions, virtually every time there's at least one, if not multiple different laws that were violated that as a result led to the collision. You were going too fast, you were following too close, you weren't keeping a proper lookout, you didn't obey a traffic control device, you didn't signal like you were supposed to. Those are all traffic laws, or as Chapter 811 is where you find most of those. And virtually every single accident you're going to have the big three: following too close, not keeping an adequate lookout, and driving too fast. And that's what we would put in the complaint if I were to sue you for negligence in an automobile accident. That you violated the following rules, and as a result, you violated your duty, which was a proximate cause of the accident. All right, so that's duty created by law. Pretty straightforward. Number 3, I want you to know this term, standard of care. This is a phrase that we use to refer to a professional when they are engaged in practicing their discipline. A doctor, a dentist, a lawyer, an architect, a civil engineer, an accountant, a real estate agent, any kind of a professional engaged in their practice, a contractor, a builder, electrician, a plumber, whatever, okay? So the standard of care basically refers to what is the professional standard of conduct for whatever you happen to be doing. Now in medicine, the professional standard of care will be set essentially by various different places, but American Medical Association, and what are the standards of that particular procedure? What are the standards for prescribing a drug? Interactions between drugs, diagnosing for potential diseases, what tests you should run. If you're doing a surgery, there are standard practices for the process on pre-op surgery techniques, materials that you use, post-op closing up and all that kind of thing, sanitary procedures, dentistry, all sorts of standards for how you clean your utensils in between, sanitizing everything. So when we use the phrase standard of care, we're referring to what is the required standard for that particular procedure. And this may change over time because of changes in technology, changes in drugs, changes in techniques. It may also change depending on where you're at in the country. If I'm a cardiologist, a heart surgeon in New York City or Los Angeles or Houston, or some of the bigger cities where I've got access to high-end medical equipment for the surgery, it's going to be a higher standard than if I'm doing surgery in Dallas, Oregon at West Valley Hospital, because I have different equipment available. So it's going to depend not just on where you're at or who you are, but the circumstances that exist. Is it emergency? Is it planned? There's a lot of different procedures there. So what does that mean? One, if you're a professional, you must know what the standard is. It's not an excuse to say, oh, I didn't know that. You have to know it. You also then have to follow the standard and keep up on any changes. That's continuing education. I put over here this term, which I probably can't read my writing, that says workmanlike. This is a phrase that's often used in building and construction, or in, any kind of a building type to say whether or not the building was completed to standards. Building standards, plumbing, electrical, all that kind of thing, was it done in a workmanlike manner? All right, so I just want you to know that phrase. So the test question would be something like, what is the term that we use to describe the duty and for negligence purposes as it relates to a professional? Answer, standard of care. Okay? And if you know that much, you're good. All right, letter number 4. Real estate. So now what we're talking about is if you own real estate, or you're the manager, like in an apartment building or a shopping mall, the owner, the manager, or you're otherwise responsible for real estate, maybe you're a landlord, or you're a commercial, you lease property for your business, whatever. You're in charge of real estate, either commercial or residential. So you have then a duty to people that come onto the property. So basically, what I'm talking about here is what happens if somebody comes on your property and they get hurt. They either trip and fall down, or something is like they go up a staircase and the boards are rotted out from dry rot and they fall through, or they're on the back deck and the post is rotten and it breaks and the whole deck falls down, or there's snow and ice on the ground, you don't scrape it up or put down de-icer or whatever. Somebody comes on your property and they get hurt, and then they sue you for negligence. So what we're going to first look at is, what was your duty that you owed to them? So basically we have 3 levels. The highest level is people that come on to your property for a commercial purpose, a business purpose. We call those people invitees. You are basically inviting people, you're open to the public, to come on your property for a business reason. Now this may be an office building, a shopping mall, a restaurant, absolutely. You know, you get the idea. So a business purpose. So the idea there is, okay, you're inviting the public to come on your property, you owe them a higher obligation than somebody maybe that's coming over to watch the Super Bowl for a party at your house. You have a higher obligation because it's a business purpose. So basically what that means is you have an obligation to go out and look for problems proactively. You go out and look, okay, is the floorboard rotten? Is the hand or the railing on the staircase solid? Is the railing on the back deck, is it solid?
Kitchen clean.
Exactly. Is it clean? Is the kitchen clean? Is the floor mopped up in a, like in a supermarket, in the produce department where it gets wet? So, question?
Just a real big one. I've experienced the place I work, especially doing security and stuff, is if all the safety devices work.
Oh yeah, absolutely.
Fire alarms.
Fire alarms, big time.
Emergency lighting, all that stuff.
Is the emergency door open
Right,
and not
yeah,
locked?
and not blocked and stuff.
Not blocked, exactly. So all those kind of things, right? So the idea there is you've got to go out and look for problems. You can't say, oh, I didn't know about it. You should have known about it. The reasonable manager in your position would have discovered the problem. So go out and look for problems, fix the problem if you can. If you cannot fix it, you have a minimum obligation to at least warn of the problem, maybe close off the area so people can't go in there. You know, whatever's reasonable for the situation. Now you may have a duty there created by law as well. So like for example, if you have a wet floor, you know, under OSHA rules, you got to put out the little yellow signs you see all the time, you know, wet floor, piso mojado, in the produce department or wherever, right? All right, so for you guys on the test, invitee, or if you just answer commercial purpose, either one is a correct answer, okay, for fill in the blank question. Next one down, lower level, still pretty high level of obligation, and that is a licensee. Licensee means permission, but not for commercial. So basically somebody's on your property as a personal guest, an invited guest or whatever. Maybe I invite you over to watch the Super Bowl or, you know, birthday party or whatever the case is. And I then have not the same standard as business, but still pretty high standard. And that's an obligation If I know about a problem, at the very minimum, I need to warn you about it, if it's something that could hurt you. So like, let's say you came over to my house to watch, the football game or whatever, and I'm working on my back porch at the time, I'm remodeling because it's all rotted out. I have an obligation to tell you, hey, don't go on the back porch, right? It's all rotted out. Maybe I need to lock the door, maybe put some yellow tape up or something. But at the very minimum, hey, don't go out there, you're gonna get hurt because it's all rotten. There's nails everywhere. I have an electrical fence to keep my cattle in. Don't go grab the fence, right?
I have a dog,
Yeah, I have a dog. Yeah, exactly.
aggressive.
Aggressive. Then you're going to have even a more duty, which we'll get to in a minute, under strict liability. Yeah. So, lower level, but still pretty high level, right? Okay. Letter C, trespasser. Now what we're talking about is somebody that comes on your property, but they're not supposed to be there to begin with, and they get hurt, and they sue you. You're like, wait a minute. You came on to my property, you broke into my house, you're robbing me, burglary, you get hurt and you sue me? How's that even possible, right? It doesn't seem right. Well, this is sometimes where in the news you read about crazy outcomes. But basically, even though somebody is on your property unlawfully, you still have some level of responsibility. So first of all, you cannot willfully injure people that are coming onto your property without permission. In other words, you can't set up a trap. So I can't like dig holes in the ground and then put like canvas and dirt over it so people fall through. I can't put landmines out there.
Don't do this.
I can't put, what do they call bungee sticks in the, I can't put like crushed glass everywhere so you cut your feet all up, right? Can't do that. That's a trap. And the reason for that is you basically don't know who you could possibly injure. Number two is another type of duty is if you have what we call an attractive nuisance, kind of a cool term right here. Attractive nuisance. This is basically a condition of your property that would be attractive to kids. A swimming pool, a hot tub, a jungle gym, something like that. You're going to have, especially the swimming pool, you're going to have an obligation to take reasonable steps to ensure that kids don't access and hurt themselves. Now, building codes will also back this up. So like with the swimming pool, depending where you're at, the laws are a little bit different everywhere you go. But at the very minimum, you're going to have a fence around the swimming pool that's lockable. Usually it's at least a 4-foot high, all the way up to an 8-foot high fence. Most places are a 6-foot high fence around the pool, like chain link or something. Hot tub, a lot of places will have rules that will require that you have cover and that it can be locked when you're not using it, which is probably a good idea anyway. You don't want people in a hot tub. Right? So you get the idea. So not a total same level of obligation, but still some. Yeah.
With the trespassing, so what's the difference in, say, what you're talking about, and then someone's breaking my house, and then I have a gun?
So if somebody's a burglar, right? They're breaking into your house. You don't really owe them an obligation. You have a right to self-defense, right? And if they're inside your house, you can use whatever self-defense is reasonable under the circumstances, which could include up to lethal force if it's reasonable. What you can't do is somebody breaks in and then you threaten them with a firearm or whatever, baseball bat or lightsaber or whatever, and they start running away. You can't shoot them in the back, right? That's going to be at the very minimum manslaughter to kill them, if not a higher level of homicide. So in Oregon, basically, if somebody is broken into your house, there's a presumption that the reasonable person would fear for their life. But you got to be careful. It's got to be reasonable. Okay. All right. So for you guys on the midterm, fill the blank question. List 4 types of duty for negligence purposes. So anything on this page is an acceptable answer. You can say either invitee or you can say commercial purpose. You can say licensee or invited guest or personal. You can say trespasser or unlawfully on your property. I'll accept any of those as answers. That's just fine. Standard of care, you can also put professional liability. That's fine too. The point I'm making on the fill in the blank questions, if you don't remember the exact term, write down kind of what you're thinking. If you're in the right ballpark, I'll give you credit for that, okay? Because you may not remember the exact term, but you remember its commercial purpose, accomplishes the same thing. All right, so back to our elements. So now, duty, basically, what is your legal obligation that you owe depending on the circumstances? Are you a doctor? Are you in charge of managing property? Whatever. Next question. Was there a breach of your duty? Well, usually that's pretty straightforward, but not always. Okay? So like, for example, a doctor. Let's say a doctor's performing surgery. Maybe it's a bypass surgery, open heart surgery, and the patient dies during the surgery. So the question is, did the doctor breach their duty? And what we're going to do is we're going to have to analyze, okay, what steps did the doctor take? Were they following all the proper procedures in terms of pre-op, during the surgery itself? Were they doing the correct things? And you'll have other doctors who are experts review the case, and they would testify in court as what we call an expert witness. And they may have differing viewpoints on it. And so that will be a decision that the judge will have to make along with the jury. Did the doctor follow the correct procedures? And if so, and the person still died, but the doctor followed all the right steps, it's not negligent because they didn't breach their duty. I mean, people die during surgery, right? Same thing. Let's say somebody falls down at the grocery store because of a wet floor, but you had your signs out there, you had just mopped it up, it's still a little bit wet, it's obvious, you put warnings out there, and somebody still fell down. Well, you can say, okay, I met my level of duty, and therefore there was no breach. That's why, especially like in a lot of grocery stores and other places, we'll keep a log. In the produce department especially, you know, when you go out and do an inspection like every half hour or something to look for grapes and bananas and things that fall down that people might slip on, wet floor, you go mop it up, that kind of thing. Yeah.
Is breach of duty and due diligence, is that interchangeable or are those two different things?
So yeah, due diligence typically refers to when you're going to buy something, you are investigating, you know, is it a business, is it profitable, if it's real estate, you're going to do environmental tests, title reports. If it's a vehicle, you're going to have maybe a mechanic look at it. So due diligence usually refers to analyzing whether or not it's a good deal to buy. Now, in terms of duty, if you're a real estate agent, or if you're involved in the marketing of a practice or a business like a broker, you have a duty to your client, which may require you, as part of that duty, to do due diligence. So like a commercial transaction, it's pretty common that we'll do an environmental study. It's called level 1. There's 3 different levels. Level 1 is basically take a look, previous uses, are there underground storage tanks, with the petroleum releases, other types of hazmat materials. And if there are, then you might go to a level 2 where they actually drill holes. And so yeah, they go hand in hand. Your duty may be to do the due diligence. Does that make sense?
So it'd be like a kind of a subheading.
Yeah, so I mean, it'd be like over here, it'd be another type of duty, which I haven't listed all.
Okay.
Yeah. You know, what is your duty? How much investigation do you need to do on the property? Like in residential, typically we'll have a home inspector come in and do a whole home inspection as part of your due diligence to determine if there's any problems. We'll write that into the contract that if there are a bunch of problems, then you can basically either renegotiate or call the deal off. All right, so breach of duty will depend on the circumstances. Injury, pretty straightforward. Physical injury, property damage, essentially the way that is compensated is through money. You're compensated for the repair costs, diminished value if it's a car or something else, lost profits in the business, medical bills, pain and suffering. We've talked about a lot of those already. All right? duty, breach of duty, injury, and that leads us to the next element, which is causation. Basically, did your breach of duty cause that injury? They all got to work together, all right? So let me give you an example of what I'm talking about. So I have plus signs right here. Keep that in mind. All four elements must be present. So, let's say I'm driving down the road. Like, let's say this is Interstate 5, okay? I-5, just south of Salem, we're at 65 miles an hour. So here I am in my car, driving down the road, and I'm going 130 miles per hour. In my brand new Audi Tron that I saw during the Super Bowl. That's a pretty cool car. I have no idea what those cost, but I'm sure they're north of 100 grand. So, I'm flying down Interstate 5. Am I negligent? 130 miles an hour. Okay, what's my duty?
65.
Yeah, 65, right? So ORS 811.111 establishes speed limit. I'm violating that speed limit. I'm also violating ORS 811.100, which is violation of basic rule. Multiple different laws I'm violating. It's also reckless driving at that speed. So, I'm breaching all kinds of duties, right? Am I negligent? Gotta have all four. Aha! Breach of duty, drive the speed limit. Breach of duty, driving too fast, clearly. But am I negligent? Aha! You're right. No, I'm not yet because I haven't caused an injury. I'm well on my way to doing so at that speed, but as of yet, we don't have all four elements. So don't fall into that trap. You guys heard the saying, no harm, no foul kind of thing? That's kind of what we're talking about. Now, I would venture to guess at least half of us in this room have breached a duty today. I know I have, I'll admit to it. I was driving up here for class, and I was going 21 miles an hour in a 20 zone. Breach of duty, but I didn't run into anybody, right? No harm, no foul. So you gotta have all four. Gotta have all four. That's kind of tricky. That's the test question I actually asked. I'm going 130 miles an hour, am I negligent? Not yet. Now, if I hurt somebody, run into them, run off the road, damage the vehicle, whatever, or hurt somebody physically, yeah, now I'm negligent. Okay. So we got duty, we got breach of duty. All right, so now some more information here. So let's say we've got a guy that lives in a house that's right up against Interstate 5. Lived there for 30 years in that same house. So here's our guy right here. So after 30 years, they don't really even notice the traffic. It's just kind of, goes on all the time. It's like, don't even hear it anymore. I'm so used to it, no big deal. So let's say that the guy has, this is a tree. That's an apple tree, can you tell? The art major, right? I love art, but art doesn't love me. So the guy's up on his ladder picking apples and falls off the ladder and is hurt. Now we have an injury. I'm driving 130 miles an hour and they fell off the ladder. Like, what? Okay, we got duty, we got breach of duty, we've got injury, but now what's the problem? Causation, right, exactly. Okay, so we only have 3 out of 4. All right, so let's say the guy here falls off and is hurt and sues me for falling off their ladder. And during discovery, at deposition, we're like, what? That doesn't make sense. You fell off a ladder and you sue me? I mean, that's your fault, right? So the guy testifies at deposition. I've lived there for 30 years. I am used to I'm used to people going 100 miles an hour even. Don't even notice it. But Hasbrook there was going so fast, 130 miles an hour, that I went, whoa, look at that guy, and I fell off the ladder because of that. Now, do we have all four elements? Duty, breach of duty, injury, and my speeding, did that cause the guy to fall off? Well, he said it did. What do you think? Seems kind of something not right about that, doesn't it? Like, okay, what does speeding have to do with you falling off a ladder? I mean, yeah, I guess. But, so this is where we get into causation. Okay? And this is where it gets kind of tricky in the real world. So you've got to link the harm to the foul. What went wrong? What did you do wrong? And the idea is that causation has two parts to it. The first part is an actual link between what you did wrong and the injury. I'm driving so fast that the guy went, whoa, and fell off the ladder. So yeah, there is a link there. There's a factor. Sometimes we call this the but-for test. But for what I did wrong, would the injury still have occurred? In other words, if I had not been speeding to that level, would the guy still fell off the ladder? If he still would have fallen off the ladder, then I have no causation. But if not, then I do. So was I a factor in the injury? In this case, yeah, I guess I was, a little bit. I think it's kind of tenuous. But on top of that, we also have what we call proximate cause. Proximity, how close something is to something else. So this is the idea that even if you factually have a link, the injury must be closely related in such a way to what you did wrong that it's foreseeable. That's why I have this highlighted. Now this is can be very, very difficult. It can be very speculative. And so the idea is that if the injury is not a foreseeable result of that type of breach of duty, then even though you had some connection to it, you're not legally responsible because it's too speculative, basically. So here's the argument then that I would make if this guy sued me. I would say it's not foreseeable by the reasonable person that my breach of duty by driving so fast would cause somebody to fall off a ladder. That is not a foreseeable event, occurrence. Now, is it foreseeable that I might run off the road and hit somebody? You betcha. Is it foreseeable I might roll my car and hit someone, or hit the guardrail, or whatever? Or even freak somebody else out that was in a different lane and they'd go off and crash. Those are all foreseeable events. But somebody falling off a ladder while they're picking apples, that's not really foreseeable, is it? I'm thinking when I'm going that fast, oh boy, I hope I don't get pulled over. I'm not thinking, gosh, somebody might fall off their ladder while they're picking apples. And the reasonable person wouldn't think that either. So the argument there is it's too far removed. And therefore, no causation. Now, for the test, I'm not going to make you write an essay on actual versus proximate cause. That's law school time. If I give you this weird, convoluted fact pattern, kind of like this, and I'm going to ask you, was that person negligent? The answer is probably no, because it's too speculative. It's too far removed, right? Does that make sense? So you read through and you're going, what? This is just like, okay, you didn't really cause that. That's the point. That fourth element has not been met. That's why I cannot emphasize enough, you've got to have all four. Duty, breach of that duty that caused an injury. If you don't have one of them, no negligence. Yeah?
So just a little clarification, actual cause, and the but for.
Yeah.
But for what I did wrong, would there still be injury?
Correct.
So you can still make the argument of like, well, he's on top of a ladder, and injury's possible on top of the ladder.
Yeah,
Is that
but for what my breach of duty. So, did my speeding cause him to fall off? That's
Or just there's a fact he's on a ladder, is that what caused him to fall off?
exactly.
Ah, okay, good.
What was the but for? What was the factual cause? All right. So now let's move on. Now let's talk about defenses. So now what we're talking about is the idea that you get sued for negligence. What arguments could you make In other words, what are you gonna argue to the judge and the jury to either try to get out of the lawsuit altogether, 100% win, you're not liable at all, or what arguments might be made that will reduce down the amount of money that you would otherwise have to pay, percentage-wise. So that's what we're talking about when we talk about defenses, okay? So these are essentially basically what lawyers would argue to the judge and jury on behalf of their client, to try to get them out of the case altogether, or to try to reduce down the total amount of money that has to be paid, usually by an insurance company. All right. So letters A and B, both of these they're similar, and both of these are based upon the idea that the injured person did something that contributed to the injury that they received, contributed or were partially at fault, or did something that made the injury that they received worse than it otherwise would have been. All right? So these are both based upon a percentage argument. So I've got this explained a little bit more on page 61. So number one is what we call a contributory fault standard. This is based upon Old English common law, well before the United States was around. And this was the idea that if a person that was hurt by somebody else's negligence, if they did anything that contributed to the cause of their injury in any way, then they could not sue the other side. And a judge would basically throw out the case. Now, that's why I put 100% or 0%. Because basically, if you are even 1% at fault, you could not sue the other side. You got no money. Even if they're totally 99% at fault, you did something wrong even a little bit, the judge is going to throw it out. You get nothing. You're either going to get it all or nothing. It's all or nothing. Yeah, it's pretty brutal. So let me give you an example, okay? So let's say I'm down here. This is a stoplight. Here I am in my car. I'm stopped at the red light. Minding my own business. Waiting for the light to turn green. Just hanging out. You come along, going 90 miles an hour. That's probably too fast. 50. Okay, 50 miles an hour. You're eating a cheeseburger, talking on your phone, flipping your radio around, not paying attention. You drink 10 pitchers of beer. You're just negligent all over the place, right? And you run into me. I go through the windshield as a result. High-speed impact. I physically break the windshield with my head and go through and land on my head and break my legs. Horrible injury. I'm now paralyzed the rest of my life. Massive medical, and we're talking millions of dollars of medical expenses, whole lifetime of lost income now. I mean, this is a multi-million-dollar lawsuit. Actually, I had a case like that once where a truck driver claimed somebody going through the windshield. Horrible case. So, long story short, I sue you, of course, because you're all sorts of negligent. But there's a problem. I was also doing something wrong. Well, what was I not doing? I was not wearing my seatbelt, exactly. So therefore, I'm now the lawyer for the person that's just like super negligent. All caps, negligent. So I'm going to argue the jury. We are really, this is a horrible situation. Clearly my client breached a duty. Clearly my client has a level of negligence. We're really sorry for the injury. It's awful. But unfortunately, Mr. Hasbrook there was not wearing a seatbelt. So he therefore contributed to the severity of his injury. And that's an awful thing, but you know what? The law requires you to wear a seatbelt. And he wasn't wearing a seatbelt. So you, jury, you've got to assign some of that percentage to him, even though he's horribly hurt. You've got to give him a percentage. And that's where I'm going to start arguing. I'm going to say, okay, 15% for not wearing your seatbelt. This person's 85%. So then a jury is going to decide, okay, what percentages are they? And they'll actually write down the percentages. So here's how it works. There are two different systems. In this type of system, if I'm 15% at fault, How much money do I get? None. Yeah, millions and millions of dollars, but because I contributed a little bit to my own injury, I get zippo. That's not really fair, is it? That's old common law. We don't really follow that anymore today. Now we go under what we call comparative fault, or comparative negligence. Basically, the jury will determine percentages, and then you deduct the person's own fault from what they recover. So if I'm 15% at fault, and the other person's 85%, if I had $100 of medical bills or whatever, you adjust it down by my own fault, and the other side would pay me 85%. That makes sense? Purely logical, right? So I want you to know the difference between the two, okay? This one is either or. You get everything or nothing. If you're a little bit at fault, the judge throws it out. That's old. We don't really follow that anywhere. Some countries still follow that standard, but we don't in the United States anymore. Most countries are on this standard now. So comparative fault, the jury will assign percentages, okay? It makes sense. So again, real world now, this is what happens more in the real world. Almost every automobile accident, there is a percentage on both sides, and that's what the lawyers, or this is what you negotiate over with the insurance company. What are the percentages? You're not really talking about 100% at fault, 0%. It's usually, you know, are we arguing 15? Are we arguing 10%? Are we arguing 5%? If I remember, in Oregon, the law will cap for not wearing your seatbelt at 5%. The law caps it at 5%. All right. So again, that's a defense. Letter C, next defense. Assumption of the risk. All right. Again, somebody sues, I'm the lawyer, this is an argument I'm going to make. In this case, I'm going to try to have my client be totally released of all liability. So assumption of the risk is the idea that the person is hurt, is engaged in an activity for which there is inherent, built-in risk in that activity itself. This is typically going to be sports-related, recreation-related, something like that. So skiing, snowboarding, skateboarding, bungee jumping, scuba diving, skydiving, horseback riding, or sports, you know, football, baseball, basketball, ping pong, whatever, right? So there is inherent risk in those activities. And by engaging in that activity, you are assuming the risk that you might get hurt as a result. And therefore, the law would say, because you assume that risk, you can't sue the provider of that activity. So I go skiing up at Mountain Meadows, and I twist my leg, catch an edge on the snow, and I blow my knee up. Or I fall down and I break my leg. That's an inherent risk of skiing or snowboarding. Now, and so then if I sued them, they'd say, you assume that risk, we're not at fault. This also applies if you are a spectator. So if I'm watching basketball, I'm front row seat at the Blazer game, cool, courtside. And when the player passes the ball and the other player misses it, the ball hits me in the face. It breaks my nose, right? Yeah, I'm injured, but I'm assuming the risk that could happen. That's reasonably foreseeable as being a spectator. Or baseball or softball where a foul ball goes off and hits somebody. Or golf, I'm a spectator and somebody hits a drive and slices over and hits me in the head. So I'm a spectator. All right? You're also assuming the risk that you might get hurt. Now, what you're not assuming, like if I go skiing, I'm not assuming the risk that I might get hurt from something that's not inherent part of the activity itself. So for example, I go up to Mount Bachelor or Mountain Meadows or whatever, I'm on the chairlift, and the company, the maintenance people didn't grease the wheels on the chairlift properly on the poles, and that creates friction, and the cable snaps, and the whole chairlift falls down, and I break my legs, right? That is not inherent to skiing. That is bad maintenance. And so I'm not assuming the risk of bad maintenance. Yeah?
When you say skiing, what do you mean? Is that replacing the word of assumption?
No, skiing, like skiing or snowboarding. Or,
Okay.
yeah, some type of activity where there's risk involved and I'm doing it voluntarily, so I go skiing, right? I mean, break my leg. That's part, I'm assuming, I'm taking on that risk and I know, hey, I might get hurt if I go
Okay.
skiing.
I get you.
Yeah, and then I sue my bachelor, I say, hey, I broke my leg. They say, well, that's your fault.
You know what you're doing.
Right, exactly. All right, now, along with that's letter E, liability release. This is a contract, contractual, where you agree that if you get hurt, you will not sue. If you ever buy a lift ticket, on the back of the lift ticket, all that little fine print, right? The purchaser or holder of this lift ticket understands that skiing, snowboarding, or other related activities are inherently risky, and you may involve injury or death, or both, and you therefore release Mount Bachelor Corporation, its employees, directors, officers, employees, and other affiliated third parties from any and all liability, injuries, property damage, which may result, including any damage for a third party, and you agree to identify, defend, and hold them harmless from all life. You've ever seen that until I write this on, right? That's a liability release. Scuba diving, right? I used to be a scuba diving instructor back in the day, and so when I'm teaching you, PADI instructor, every day I give you a form. Every time you learn something, you sign, yes, I understand if I hold my breath and I blow up my lungs. And you sign it. That's a liability release, okay? So the courts typically will uphold those. All right, enough said on that. So, let's say you go to a hockey game, you're a spectator. What's the risk you're assuming? You're up in the stands.
Puck flying.
Yeah, a puck might come out and hit you, right? I mean, they put, the plexiglass up and stuff. All right, you are at a baseball game. You're watching the game. Might be a foul ball or something like that, tipped off or whatever hits you in the head. Let's say you go to a fight. You're a spectator at a fight. What risk are you assuming as a spectator? That a hockey game might break out.
So I
It's a
didn't.
joke. Went to a fight and a hockey game broke out. It's a Minnesota joke, right? I know it's really bad, but it's like today. I had a friend from Minnesota. He tell him all the time. Went to a fight and a hockey game broke out. Yeah.
Well, so but on that note, I guess if you went to a sporting event and a fight broke out and you were injured as a result of two other guys around you fighting, you're like, what's going on?
Yeah, that's probably not an inherent risk
It's not.
unless, you're a Patriot fan or something, but it's not an inherent risk of that activity itself.
Okay.
Or if it's, if you're in Europe at football, that happens all the time. No, you would, that would not be an inherent risk. So the people that, they're brawling and they roll over onto you or something, yeah, you could sue them. You're not gonna. Now, could you sue the facility? That would be a different question, because you still have to prove causation. You have to prove breach of duty and that they caused it. So,
Like if they're overserved or something like that, or.
overserved, something like that, absolutely, absolutely. All right, letter D, last clear chance. So this is the idea that somebody gets hurt, somebody else is negligent. So like, let's say you're a pedestrian in a crosswalk, and I'm driving down the road and I don't see you, and you see me coming. So this is the idea that you get hurt, yes, I'm negligent, but you could have got out of the way. You had the chance to avoid being hurt, but you didn't take that chance. You basically froze up. You're in the crosswalk, you see me coming, you're like, oh, there's no way Hasbrook's gonna stop, but you freeze, I splatter you. You guys ever see the Austin Powers movie, Mike Myers? I can't remember which one is the spy, the goofy spy movie.
What?
Oh, what's it called? Just driving me crazy. Anyway, there's a scene where he's on this steamroller that's going really slow, and there's a security guard going, oh, don't run me over, and it's like 5 minutes, and he could have jumped out of the way. And you guys probably don't know what I'm talking about, but that's this idea. You could have jumped out of the way, yeah.
How do you measure that? Because couldn't you technically say?
Would the reasonable person have done the same thing? That's
No,
how
we get out the way.
Yeah, get out of the way. I mean, you see a car coming, like even, from this wall to where you are, 40 miles an hour, you still have an opportunity, and we can do the math on it, physics, what your reaction time is, probably 1.2 seconds. And the car's traveling this much distance, so you had a half a second to jump out of the way. They're actually, it's called an accident reconstructionist. There are people that do that. They have computer formulas to do that. Now, let's say you're on the jury then, okay? Let's say I run somebody over in the crosswalk. You're on the jury, and I'm saying, oh, they should have jumped out of the way even though I'm going 50 in a 25 zone. You're on the jury, you know, are you gonna say, are you gonna buy that argument? Not really.
I would.
I mean, it's like, okay, come
Where do you head?
on. Okay, if somebody's in a crosswalk, you get run over. All right, so last clear chance. You could have jumped out of the way. Last one, insurance. Insurance isn't really, well, it is a defense in a way because this is why you buy insurance, in case you get sued for negligence. And that's automobile insurance is a form of what's called liability insurance for negligence, commercial business insurance, property and casualty insurance in case there's a fire, employee theft insurance or employee action insurance, errors and omissions. All these different kinds of insurance we have, that's a different class, but that's why you buy it. In case you get sued for something you did wrong or somebody that's your employee, contractor, or somehow affiliated with you. All right. So, for negligence, again, just to review, 100%, I will ask you, what are the 4 elements? Duty, breach, injury, cause. DBIC. What are some defenses to negligence? So again, I'll show you that test question again. What are the elements? DBIC, right? I want you to write them out though. Duty, breach, don't just put DBIC. I've actually had students do that before. I won't give you full credit. What's the defense to negligence? Name 1 out of the 5 or 6 I gave you. Insurance, contributory fault, last clear chance. You get the assumption of the risk.
How many questions did you take?
Okay, for fill in the blank questions like this, there'll be a total of 40 blanks. Usually I run about 10 questions with 4 answers each.
40?
10 questions with 4 answers, so about 40 blanks, right?
And there's no notes?
No notes.
All right. I'll remember.
Yep. And we'll talk about the midterm here in a minute. All right, let's move on to the last area of tort law. Remember, we have 3 different types of torts. Intentional, on purpose torts. Unintentional, negligence. The third area of tort law is what we call strict liability. This is on page 63, which I call no fault tort law. In other words, fault is irrelevant, intent is irrelevant, breach of duty is irrelevant. This is basically an area where somebody gets hurt and you pay no matter what, even if they cause their own injury. No fault. Very limited area. So when does this apply? So first of all, if you are engaged in an activity that by law assigns strict liability to the person in an ultra-hazardous or abnormally dangerous activity, so this would be, for a classic example, would be use of explosives. If I'm mining, demolition, road building, fireworks show, other areas where I'm using explosives, A, I'll have to get a permit. B, as part of that permit, I'll have to have an insurance policy. But also the law will say you are strictly liable for any property damage or injuries that result from the explosives. So I blow up, I'm doing road building, and I blow up a big boulder, and a rock flies a half mile away and hits somebody in the forehead. I'm like, didn't know I was going to do that. Too bad, I pay, no matter what. Oftentimes, we will also have laws that assign no fault liability if you own a dog or other animal and it hurts somebody, bites them. Instead of arguing over who's at fault and whether the dog's aggressive or not, you pay. You pay for their medical bills. Some places that's absolute. Even if the dog's defending you, you still pay. Not very many places like that. There were actually some cities in California that had no fault absolute dog liability, and then a burglar broke into somebody's apartment and the dog attacked the burglar. The burglar sued the homeowners and won. Because the law said no matter what, you have to pay. They have since changed that law. That was like 15 years ago.
Is it fair?
What?
Fair? Is it fair?
Okay, well, most of those laws now would say, so long as there was not a self-defense situation or the dog was being provoked. But like if I'm just walking down the road, with my dog, and somebody walks by, my dog bites them, I'm gonna have to pay for their injuries. All right, letter B. This one's probably the most important one for you guys that I want you to know. Workers' comp. So again, strict liability, no fault. So workers' compensation, employee injuries, I'll accept either as an answer, that's fine. If I'm an employer and I have an employee that gets hurt on the job, even if, if it's their own fault, I have to pay for their medical bills, disability, either permanent or temporary, lost wages, that kind of thing. I have to carry workers' compensation insurance. If I don't, I'm personally liable, no matter what, even if I'm a corporation. And so, this is a form of strict liability. So here's what I mean. Let's say I'm a construction company. One of my employees is cutting 2x4s to make studs for the wall. And they cut right through their hand with a chop saw. Yeah. Horrible, right? They want their fingers. Not my fault. They cut their fingers off, not me. But because they're my employee, I am strictly liable to pay for their medical bills. Permanent disability in that case, lost wages, etc. That'll be separate. All right, letter C is the third one, and this is for defective products. We call this product liability. And this is the idea that I'm a manufacturer or like a food producer or whatever, and I have a product that's defective and unreasonably dangerous. I therefore have, an obligation to recall the product, and 2, to warn the public, and 3, if somebody's hurt, there could be a strict liability standard, meaning I pay no matter what. So this would be like for E. coli, salmonella, listeria, for food. If I'm aware that products are contaminated, I need to recall them, otherwise I have strict liability. So basically it doesn't matter fault. If somebody eats it, and I end up paying for it. Okay, so possible fill in the blank question. What are 3 areas where strict liability applies in tort law? Defective product, dog bites, explosives, abnormally hazardous activity, workers' comp, employee injuries. Any of those is a fine answer. Okay. All right, so that's the midterm line right there. So the midterm will cover from page 1 to page 63. So the midterm is next week. You will need a Scantron form. Scantron form, the little computer form to put your answers on. You fill in the little blank thing. Question? All right, so you'll need a Scantron form. Get those at the bookstore. On the Scantron, you're going to put all the answers for the true and false questions and multiple choice. So there will be a total of 40 true, false, multiple choice, with about 15 being true, false, and the rest are multiple choice. And there'll be fill in the blank questions like what I showed you earlier. And there'll be roughly 10 fill in the blank questions with 4 blanks each. So a total of 40 blanks for you to fill in. So 40 on the Scantron, 40 fill in the blank. All right? Now, the fill in the blank questions, I write myself, and they all come out of this blue book. The true, false, multiple choice are questions that either I write myself or that I get from the textbook people. And for you guys, the extra credit that's on Moodle, the questions on Moodle, the true, false, and multiple choice, are really similar to what I will ask you. So I highly recommend that you do those questions before the midterm. It will help you study. It will help you see the questions and what they look like. Sometimes they're even the same questions because they come from the same database that I use when I'm assembling a test. I have a software program where I just hit how many questions. I want 15 true, false. I want 25 multiple choice. I hit enter and it will automatically make a test for me. That's where it comes from. All right. Now, let's go through the pages that are likely to be fill in the blank, starting at page 3. Lists 4 categories of law, and again, I want you to know about a little bit about each one, primarily civil versus criminal. Again, how do you tell the difference? Jail time. No jail is civil, jail time is criminal. Page 4, 100%, fill in the blank. Name 6 sources of law. And then I want you to know which branch of government creates those sources, legislative, executive, judicial. And I want you to know primarily federal law, the level of authority. Constitution, of course, is the royal flush. It beats everything. All right.
As in list 6, you mean for federal and state?
Oh, anything on this page. Federal, state, city, county, yeah. So,
So you could do all 6 federal?
absolutely, that's fine. Yeah, anything on this page is fine. Okay, page 11. What are 3 fundamental concepts of constitutional law that start with the letter S? And I also want you to know what they are. Supremacy. Federal law is higher than state law. Separation of powers.
Do you want us to put like separation of power or just separation?
Separation of powers, yeah. Separation of powers and stare decisis. Stare decisis, remember, is previous court decisions, precedent. This is only an 80%, but I do want you to know what those 3 theories are, okay? Because I'll have true, false, multiple choice questions on that. All right, page 14. Not really fill in the blank, but just a highlight. Remember, this is on a court case. How do you read it? Plaintiff versus defendant. I want you to know the plaintiff is the person who filed the lawsuit, defendant's the one that's being sued. And I want you to know the citation, where the first number is the volume, that's on the outside of the book, the abbreviation, and then the page number is the second number. All right. Page 17, possible fill in the blank, 40% is all. Lists 4 different types of schools of thought for jurisprudence, but I do want you to know the difference here between the 2 major ones. Remember, legal, this is like theory of law. How will a judge decide? Can they deviate from the written rule? Positivism, no deviation. Follow it exactly as written. Natural law, flexibility. All right, page 20 and 21. Pretty much 100%. What are 6 types of jurisdiction? There are 10 of them. Trial court jurisdiction, original jurisdiction, appellate court jurisdiction, exclusive jurisdiction, concurrent jurisdiction, next page over, personal jurisdiction, subject matter jurisdiction, in rem jurisdiction, federal diversity jurisdiction, and federal question jurisdiction. So out of those 10, be able to list up to 6, probably only 4, but. And I want you to know how do you get to federal court? Either through federal diversity, or if it's a federal law, you go every time. All right, page 24. What are 4 courts arising or within the state of Oregon? And I want you to know the 2 primary trial courts, circuit court at the state level, and federal district court at the federal level. Page 26, 100%er. What are 6 methods of dispute resolution? Anything on this page? And I also want you to know the difference between mediation and arbitration. Mediation, neutral third party, will not make a decision. Arbitration is like a private judge. They will make a decision. Okay, page 27. List 4 steps in proper order in a civil lawsuit. CAD, TVA, exactly. Complaint, answer, discovery, trial, verdict, appeal. Those are the main steps I want you to know. All right. Page 29. list 4 types of pleadings. Is there anything on this page? And I want you to know who files them, plaintiff or defendant. Remember, it's easy to remember. If it has a PL in it, it's the plaintiff. Reply. Reply and complain. All the other ones are the defendant. And the 2 purposes of pleading, statements of fact, what happened, and what remedy are you asking for? What happened and what do you want? Money or no money, like a court order. Money is a legal remedy. Court order is an equitable remedy. Okay, page 30. What are 4 methods of discovery or 4 discovery tools? All right. Page 43. 4 areas of exclusive federal power. Possible, not every time do I ask that. Page 44, what are 4 types of checks and balances? So anything on that page? Page 56, 100%, again, list up to 6 types of intentional torts. So anything on these 2 page 56 and 57, there are 17 of them to choose from. Then back to where we were today, page 59, 100% negligence. What are the 4 elements? That's that, I already showed you that. What are 4 duties? Possible fill in the blank. And then finally, page 63, 3 areas where tort law, or strict liability applies in tort law. And then that's the end of the midterm. All right. Now, extra credit. Extra credit, you don't have to do it before the midterm, but I highly recommend you do, at least the online questions, okay? You got the whole term though. So you can, like, a lot of people will just hold off on the handwritten ones, see how you do on the midterm. That way if you need to bring your grade up, you can do it later on. But I do recommend you do the online questions because it will really help you study. All right, any questions about the midterm? Yeah.
I just noticed on page 8, I just noted moving on the test. How do you cover that?
Oh, okay, yeah, that page 8, page 11.
Page 8,
Yeah, they're the same information. And stare decisis basically means precedence. Any other questions? No? All right, we're done for tonight then. You guys go study. Be careful in the snow if it does snow.